All right. Hi, everybody. Welcome to another episode of Logically Speaking. Today, we're going to be talking about a common question that I see online or posted or asked when cases are, for instance, like on the news. And maybe there was a case where, in a criminal case context, where somebody had allegedly committed a crime and they were caught in the act or caught at the scene, or even if not, something happened, but they were arrested for the crime and they go to court for what's called their arraignment or their first appearance, and they enter a plea of not guilty. And I often see asked in those scenarios on, comments to the cases, or I'm even asked myself of why in the world did this person plead not guilty when it's pretty clear that they did it or they were caught at the scene or anything like that. Today, we're going to answer that common question of why does a criminal defendant plead not guilty initially in their case? And that is solely because it's a standard practice. It's what we do as criminal defense attorneys and in the criminal case context. Is we initially go to court at the arraignment at our first appearance. It's called different things in different states or different areas. But that is the initial plea that a criminal defendant is going to do, is enter a plea of not guilty, because that allows us to then participate in the discovery, the criminal discovery, and through the criminal system. Once a defendant changes their plea or enters a plea of guilty or no contest, they go right into sentencing. And there's a lot of things that need to happen before we get to that plea of guilty or to trial, and then the ultimate to sentencing if they're found guilty or they enter a plea of guilty. So that plea of not guilty allows us to enter into all the things that need to happen inside of a criminal case. It allows us to get to do this discovery process. The discovery is the exchanging of the evidence, where the state attorney, the prosecutor's office, has to give the defense attorney all of the evidence that they have in the case. And if we're going to go to trial in return, the defense has to then give their witnesses and their evidence or discovery that they're going to be using at trial. It allows us to do any type of mitigation. If we know we're working towards a case that's ultimately going to end in a plea of guilty or no contest to go into sentencing, entering an initial plea of not guilty also allows us to work into mitigation, things that we might need to do where we're going to be making arguments to the judge for a certain sentence that we may be asking for on the defense side. So it allows us to bring in and get evaluations by mental health experts, or to get some sort of character type of evidence for on behalf of the defendant, or just any type of other things that we are going to be presenting to the court as we try to work on and negotiate a sentence either with the state or with the judge. So there's a few reasons why through the system and a defendant initially enters a plea of not guilty, so that we can go through the court process, do the things that we need to do to ultimately get to some sort of resolution or outcome, whether that goes to a trial where we go in front of a jury or in front of the judge to have the determination of having the state prove guilt beyond a reasonable doubt, or whether that is to negotiate and mitigate down into some sort of plea negotiations to an ultimate sentence. So I hope that answered a really common question that I've seen posted. And if you or someone you know is going through a case, please feel free to contact our office and we can see what we can do to assist you. We'll see you on the next show.